Concern, Mr. Gillery, that you come in, plead guilty, and then you go say, well, I didn't really do it. Somebody follow the agreement that you made with the district attorney, defer all proceedings, place you on probation for 3 years.
A guilty plea should mean accepting responsibility. But in this sentencing hearing, the defendant appeared to tell the judge something very different, that he was guilty, yet someone else had actually committed the burglary. The judge immediately stopped and addressed the contradiction. He explained that if the defendant truly did not commit the crime, a jury could decide the case. But if he did, accepting responsibility was part of moving forward. The judge then made a decision that gave the defendant a chance to avoid a felony conviction, but with serious conditions attached. Let's start the case.
Mr. Lewis, you've got Broadick Gillery. It's a sentencing.
Yes, ma'am. Judge, I'm signing paperwork on Mr. Kelly's case. So.
Thank you. Ms. Malfino on Broadick Kelly. Good morning, sir. Are you Broadick Kelly?
Broadick Gillery.
Gillery, I'm sorry.
That's what
I don't know why I was saying Kelly, I guess because I just called Mr. Kelly's case. You're Broadick Gillery. Sorry, Ms. Malfino. No wonder you couldn't find that file. It's a sentencing. Yes, ma'am. That's because you know how to read my mind. Everybody else doesn't, apparently. All right. Mr. Gillery was previously in court in cause number 25 DCCR 1716, entered a plea of guilty to the state jail felony offense of burglary of a building. I've received that pre-sentence report. Have you both had an opportunity to review the report?
I have, Judge. There is something that we definitely want to address, and I've spoken with Mr. Gillery about it, and he would like to address it for Judge to
Okay.
speak on it.
Go ahead.
Yeah, I was in the paperwork. I was a little nervous talking to the
Speak up.
I was a little nervous talking to the woman about probation,
Yep.
and I basically wanted to say that I did what I was guilty for.
Okay. So it gives me concern, Mr. Gillery, that you come in, plead guilty, and then you go say, well, I didn't really do it. Somebody else did it. Accepting responsibility is sometimes hard, but it's something that you do, especially as an adult and when you've done something like this. So if you didn't do this, someone else took your truck, did all those things, then we'll have a jury come in and they can decide. If you did it, then just accept the responsibility because things will go a whole lot more smoothly between now and the end of this probation, hopefully. Does that make sense?
Yes.
All right. Anything, Ms. Malfino, other than that?
was my concern.
All right, then, Mr. Gillery, at this time, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, but I'm going to follow the agreement that you made with the district attorney, defer all proceedings, place you on probation for 3 years. You're ordered to pay a $500 fine. You're also ordered to pay restitution in the amount of $4,600 and to follow all of the other rules and conditions of probation. If you do that, this is a great opportunity. You don't have a felony conviction on your record, and at the end of the probation, if you successfully complete it, you'll never be a convicted felon. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty, so you would be a convicted felon, and you could go to the state jail prison for between 6 months and up to 2 years. Do you understand?
Yes.
$4,600 is a lot of money to pay back. And a lot of people will think when they have restitution, I've got 3 years to do it. I'm going to wait. I'm going to sell something, or I'll wait till I get my tax refund or something like that. I want you to make payments on that every single month. Even if it's a little bit, it'll add up. Because what can happen is if you don't make payments on it, we can get to the end of your probation. You could have done everything else right. And if I find that you could have paid that restitution and you didn't, then you could still go to prison and be convicted, even though you've done everything else right but pay that money. It's very important that that gets paid back. And if you'll just make sure, I want at least half of that. Anything he pays going to that. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. If you'll just have a seat here in the courtroom, probation will call you up to her desk when she's ready to go to your paperwork. All right, good luck to you, sir. Thank you.
Thank you.
You've got Michael Thomas, Mr. Lewis.
Yes.
Good morning, sir. You're Michael Thomas Jr.
Yes,
And this is 23 DCCR 0530. Mr. Thomas is set for trial with jury selection Monday. And what is the announcement?
Ready.
Okay, good. All right. So, Mr. Thomas, has there been any change in any kind of negotiations or anything like that? So it's very likely that your case is going to be at the top of the list. It's obviously very old, need to get it taken care of. Stay in touch with Mr. Lewis. He will know that trial order tomorrow, right after lunch, probably. But I anticipate seeing you next Monday at 1 o'clock. Okay. All right. See you then. And then you have a Charles Tucant, Mr. Lewis.
Yes, ma'am. Yeah. He's outside of the wheelchair, Judge.
Okay. Go get him. Good morning. You're Charles Tucant,
Yes, ma'am.
and this is cause number 26 DCCR 0527. And what is the announcement?
Judge, there's some additional medical records I'm waiting on. I was able to, Mr. Tucson, I was able to talk to the nurse this morning. They're compiling that together, the rest of it that I need. So hopefully I may have it today.
Okay.
But I can just have one more setting so I can review.
All right. Any issue, Mr. Smith? So, Mr. Tucson, I'm just going to do a normal reset. That's about 30 days to give you some time to get everything you need to Mr. Lewis so he can get it to Mr. Smith. They can talk about it, and then you guys can visit, see what your options are, and we'll get that figured out at the next court date.
Thank you.
All right. You're free to go.
Thanks,
Thank you.
Judge.
Mr. Rojas, you got Tyler Douglas. This is Ms. Malfina. Oh, sorry.
Thanks, Judge. I think
You were already walking it? Thank you, Mr. Nichols. Good morning. Are you Charleston A. Verdine?
Yes, ma'am.
And Ms. Verdine was previously in court and entered pleas of true to counts 1, 2, 3, 4, and 5 in a motion to revoke her probation, is on probation for obstruction or retaliation. It looks like there was an agreement, but we got a updated pre-sentence report. Is that correct?
Yes, Judge, just to make sure you were.
Okay. You both had an opportunity to review that.
we have, Your Honor.
Yes.
Any other additions or corrections to that report?
No, Your Honor.
And I see probation's here. Is there any other thing you would need to add as far as what the recommendation is in that report? Okay, thank you, ma'am. All right, so Ms. Verdine, it looks like everybody here is willing to give you an opportunity to try to be successful on this probation. And so what I'm going to do is find that you previously entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I'm not going to do that. I'm going to follow the recommendation, continue you on probation. I'm going to extend your probation for 2 years. So it'll be extended for 2 more years. You're ordered to enter and successfully complete the JCDI program, which is a drug program. It's outpatient, but you have to get through that whole program and the aftercare and everything. And if you do all of that, that should hopefully have you on the right track to being able to be successful and getting this probation over with and not having the conviction.
Yes.
Here's the other side to all of that. Now that you've already had a motion to revoke your probation, if you end up back in here on another motion to revoke, things will probably not go this smoothly. Do you understand?
Yes, ma'am.
All right, so I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Do you need to talk to her before she leaves today? Make sure you stay and visit with your probation officer before you leave today, okay? All right.
Question.
Yes, ma'am.
Since I'm gonna be on the JDC, can I get the jail tax? I still got.
That'll probably be part of that program. It's up to them at this point. I had it on as a bond condition, but a lot of times they will require it. It's going to be up to them. I'll let them make that decision.
Yes, ma'am.
Okay? Thank you. Good morning. You're Jana Fine.
Yes, ma'am.
Ms. Fine, before we go forward with your sentencing, I'm going to have you drug tested today to make sure you're clean, okay?
Okay.
Have a seat in the jury box. We'll get that done first. Michael Garrett, looks like I'm signing a dismissal of Mr. Garrett's case now. He's free to go.
Okay, thank you.
Yes, sir. I know.
Client of mine, Rodney Haynes, is one I just signed up, retained on. He was down in misdemeanor court. Everything was taken in custody out of this court. They brought him over here. It looks like he had a drug patch that came back positive. So I don't know, is he setting up no bond as of now? How do you?
No, I usually set a bond. There's a bond set. When I raise it, I usually look at what the original bond was and raise it. Ms. Holmes could probably look at it.
Right.
Oh, you may be mad, huh? If you want to,
Other one was on.
yeah,
Is the-
yeah, you might want to just, if you want to file something, I'll take a look at it, but
Okay.
obviously it was. Good morning, sir. You're Dr. Blewett.
Yes, ma'am.
Good morning, Mr. Kelly.
Morning.
Will your client waive the formal reading of the indictment and the motion?
Yes, we do. And I wonder if, clearly we're pleading open, but we also don't really have an agreement on which violations of the motion we're going to plead to. We're going to plead to the aggravated assault, obviously, some of those that are.
I'll go through probably the whole thing since it's unagreed.
Thank you.
All right, Mr. Blewett, in cause number 26 DCCR 0362, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon, and that's from February 1st of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with? In that case, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kelly? Do you fully understand them? And it looks like there is no agreement, and so you have not waived your right to appeal, but you're leaving your punishment up to me. Is that your understanding?
Yes.
I want to make sure you understand you have an absolute right to have a jury come in and decide 2 things. The first would be to decide if you're guilty or not. And then if they find you guilty, you could leave your punishment up to that jury. If we go forward this way, you're waiving that right. And is that what you want to do? Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection to number 1, Judge.
It's admitted. Is there any evidence that Mr. Blewett's not competent?
Not at all, Judge.
All right, then, and Mr. Blewett, in clause number 260362, find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. And then in cause number 22-41150, I have a first amended motion to revoke your unadjudicated probation. This shows that you were placed on probation September 13th of 2023 for the offense of evading arrest or detention with the use of a vehicle, and that was an 8-year deferred probation. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you committed the offense of aggravated assault with a deadly weapon on February 1st of 2026. And is that true or not true?
Yes, ma'am.
True or not true?
Sure.
Count 2 alleges that you were at a residence or at a location other than your residence at 12:32 a.m. on February 1st of 2026. And is that true or not true? Count 3 alleges that you committed the offense of harassment on February 1st of 2026. Is that true or not true?
Not sure.
Count 4 alleges that you failed to avoid injurious or vicious habits by brandishing a loaded firearm during the assault of Alondra Cantu on February 1st of 2026. Is that true or not true?
True.
Count 5 alleges the same thing, really, but that you have failed to avoid injurious or vicious habits by brandishing that loaded firearm, and a child was also present, and that's on February 1st of 2026. Is that true or not true?
Right.
Count 6 alleges that you associated with a disreputable person, to wit, Daniel Clark, or that you were at a location where a criminal act was being committed on February 1st of 2026. Is that true or not true?
Not sure.
Count 7 alleges that you failed to immediately report to the probation officer your arrest from February 1st of 2026. Is that true or not true? Count 8 alleges that you became intoxicated or were under the influence of an intoxicating substance February 1st of 2026 in violation of your probation order. Is that true or not true?
Sure.
Count 9 alleges that you possessed a firearm and ammunition in violation of your probation order, and that's from February 1st of 2026. Is that true or not true? And then count 10 alleges, that's really the same as 8, so I'm going to skip 10. All right, did you enter your pleas of true to counts 1, 2, 4, 5, 8, and 9 freely and voluntarily? And did you plead true to those counts because they're actually true?
Yes, ma'am.
I also have here on the tablet, in that case, some documents that have your signature on them, but the state's marked as exhibit number 1. Did you also go over these with Mr. Kelly before you signed them?
Yes.
And it looks like the same thing in this case. You guys do not have an agreement with regard to punishment. You're just leaving that up to me. Is that your understanding? And that you will have some rights to appeal depending on what happens. Do you understand that as well?
Yes, ma'am.
State tenders number 1.
No objection, number 1, Judge.
All right, it's admitted. All right, Mr. Blewett, in that case, I'm going to find that you entered your pleas of true to counts 1, 2, 4, 5, 8, and 9 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm going to reset this case as well for sentencing. We'll get an updated report on that one. Anything that you think is important for me to know, get that information to Mr. Kelly. He'll present it to me on your behalf when we come back. Is this something that we need a little extra time on?
I believe so, Your Honor. My understanding is that Mr. Coleman is going to present some punishment evidence whenever the hearing is set, so you're
Okay.
going to have some extra time for that.
We'll just set it at an 11 o'clock on a regular date, but at 11, so that we have a little extra time for anything like that. Okay? All right. Thank you for being here. Y'all can go back to the bailiff, or you can go back. Not at all. All right, ma'am. Again, you're Jana Fine.
Yes, Your Honor.
And Ms. Fine tested negative this morning for everything, which is good. Was previously in court and clause numbers 26, DCCR 0432 and 0433, entered pleas of guilty. I've received that pre-sentence report. Any other, have you both had an opportunity to review that?
Yes, Your Honor.
I have, Judge.
Any additions or corrections?
No, Your Honor.
Judge, I would just ask that the court consider, as the report indicates, that she be enrolled in JCBI. And also, would you please admonish her about either getting a job or continuing her schooling? She seems like she's on the right path. We're going to dismiss her misdemeanor, but
Yes.
thank you.
I will. Thank you. All right. So, Ms. Fine, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find sufficient evidence in each case to find you guilty. However, cause number 0432, defer all proceedings and place you on probation for 5 years. You're ordered to pay a $500 fine in that case and to follow all of the rules and conditions of probation. And I'm going to go over some of those with you in a minute. And then in cause number 0433, also defer all proceedings and place you on probation for 5 years. You're not going to have a fine in that case, but be required to follow all of the rules and conditions of probation. One of those is that you will be on the specialized mental health caseload and be required to continue any treatment through the Spindletop Center. That's now not just something that if you feel like you need to do, it's something that I'm ordering you to do. And that's to make sure that you stay on the right track, get any help that you need so that you can be successful. I'm also ordering that you either complete school or get your GED.
I graduated high school.
You did graduate? Okay, good, great. Okay, I'm sorry I missed that.
I graduated through Pathways Learning.
Good, okay. So, anything else that probation feels like would be helpful for you that they say you need to do, you need to make sure and follow through with all that. Because this is a great opportunity. You don't have felony convictions on your record right now. And if you successfully complete the probations, you will never be a convicted felon, which is huge. The other side of that, though, is if you violate any condition of probation, you can be brought back into court. You could be found guilty in each of these cases. In one of the cases, you could go to prison for up to 20 years, and in the other for up to 10 years, just for not doing your probation right. Do you understand?
Yes, Your Honor.
All right, I'm handing you in each of your cases the trial court certifications that shows that these were agreements that I followed, and so you waived your right to appeal. If you'll just have a seat here in the courtroom, probation's going to call you up when she's ready to go over your paperwork. All right? Just right over here is fine. Just in the courtroom, just watch for her to call for you.
And I don't think she had an attorney on that case, Judge. So if you don't mind, I'll just let her know she does not need to go down.
Okay, thank you, Ms. Muffino. Mr. Jeffries on Artist McCoy.
Yes.
Okay, so Mr. McCoy, you tested negative, which is great, but it is extremely important that you have that drug patch on and that it's testable every single time you go to get it changed every 2 weeks. I got a notification that it wasn't testable, and so that's what caused us this issue. And there also was a positive from the last, looks like the one that was placed in July. So that was a little time ago, but we got that one back and it was positive for cocaine, but it's been negative since. So any issue, Mr. Nichols?
Judge, his DWI case involves a high level of alcohol intoxication plus possession of cocaine. So that's my concern. I do expect there to be at least 2 possession case is coming. The lab website was not working this morning, so I wasn't able to double check the status on those, but I do expect that to be coming down pretty.
So you've got the drug patch on. You've also got your auto ignition interlock on. They did send me notification that that was taken care of. It's very important that you follow all of those rules. You cannot drive a vehicle without that on it. You can't borrow a vehicle. You can't. If you do and you're caught, obviously it's going to be a violation of your bond. Your bond will be raised immediately. If you have another untestable patch or a patch that tests positive, obviously that's going to be a violation of your bond, and I'll have no choice but to raise your bond as well. Do you understand? So what I'll do is let's just do, if we're waiting on, we'll do maybe about a 45-day reset, see where we can get
That
with
should be
other
enough.
cases.
Get done, Your Honor.
And that way y'all have everything and we can try to get everything taken care of at the same time. Stay in touch with Mr. Jeffries. He'll let you know when you need to be.
This sentencing hearing centered on Broadick Gillery, who had previously pleaded guilty to a state jail felony burglary of a building. But when the case returned for sentencing, Gillery appeared to raise a serious contradiction about responsibility for the offense. The judge expressed concern that he had pleaded guilty and was now suggesting that someone else had actually committed the crime. The judge explained that if Gillery maintained he was not responsible, the case could instead be decided by a jury. Ultimately, the court accepted the guilty plea and followed the agreement with the district attorney. Gillery received 3 years of probation, a $500 fine, and $4,600 in restitution. The judge emphasized that successful completion of probation could allow him to avoid becoming a convicted felon. But there was a major warning. Failing to comply with probation conditions, including making restitution payments, could bring him back to court and expose him to a state jail sentence.